Hi guys, it's Kathy. I hope you're doing well. So if you remember where we left off yesterday, the pro se guy against the state accuses him of domestic violence, aggravated assault, something like that. He grabbed his ex-wife's throat, pushed her up against the wall. He didn't squeeze or strangle her or anything, but they had wanted to play a video, and they wanted to skip a part that brought in his past criminal record, and he objected to that. Now, I don't think they understood why he objected, but it doesn't matter. The judge is not letting the whole video in, so his prior criminal acts aren't coming in, except for the fact that he already told the whole jury what a lousy criminal record he has in his opening statement, but we're going to ignore that. We're going to forget about that. So now the jury is coming back in after this objection.
Okay. All right, you can have a seat. Everybody can have a seat. All right, you may proceed with your direct examination. In trying to recall where we left off, I asked you if there was any further information that you obtained from Ms. Boggs about her relationship with Mr. Boggs, and you went into that you provided her a Vine pamphlet.
Yes, ma'am.
With information about a temporary protective order. What else does that pamphlet, I guess, provide to her?
There's also what's called Gateway. It's an assistance for to speak out with other people that have also been in the same situation that she has been. And the numbers, 911, and the non-emergency numbers for Gainesville and the county sheriff's office, etc.
Okay.
Did she indicate, I guess...
Hold on a second. I need to bump it back a minute. I want that feed. That's the feed I want. If you look at the television...
In trying to recall where we left off, I asked you if there was any further information that you obtained from Ms. Boggs about her relationship with Mr. Boggs, and you went into that you provided her a Vine pamphlet.
Yes, ma'am.
With information about a temporary protective order. What else does that pamphlet, I guess, provide to her?
There's also what's called Gateway. It's an assistance for to speak out with other people that have also been in the same situation that she has been.
Look at that. Why can't we have that feed? Look how great that is. You can see everybody clearly. How do I get that feed right there? Other people have it. I can see people talking over there. Interesting. I'm thinking. I got an idea.
And the numbers, 911, and the non-emergency numbers for Gainesville and the county sheriff's office, etc.
Okay. Did she indicate, I guess, they were divorced, correct?
Yes, ma'am.
Did she indicate that they had previously lived together?
Yes, ma'am.
Did she say, I guess, when they previously lived together? Do you recall?
I'd have to look at my report real quick because I believe I put that in there.
Okay. Do you still have it?
Yes, ma'am, I do.
Okay.
So it says that they were divorced in September.
You want to know how I know you're a liar, Bill? Because I am a member of American Courts.
17, and she moved out in 2018.
Okay. Did you see any marks on her person?
No, ma'am.
Had you seen marks, would you have taken pictures normally?
Yes, ma'am.
And just to be clear, the location where this incident occurred on Hancock Ave, Hall County?
Yes, ma'am.
It's in Hall County?
Yes, ma'am.
And I know she gave you the name of Michael Boggs, but you were unable to make contact with him on this particular, I guess, at this particular time on April 8th.
Yes, ma'am.
Did you, I guess, research him? Were you able to, I guess, visually identify him in any way?
Yes, ma'am. Through our RMS system, our report managing system, and also based on his name and date of birth, I was able to see his driver's license photo.
Okay. And do you see that person in the courtroom today?
Yes, ma'am.
Can you identify him by our article of clothing?
Wearing jeans, white shoes, and a dark blue long sleeve.
Okay. And, you know, body cam is one thing, being there in person is another. How would you describe Alicia's, I guess, demeanor in your interaction with her?
She was calm for the most part, but also you could tell that she just went through something. She was a little paranoid because of her thinking that he was in the area.
Okay. And when you're kind of, I guess, assessing whether an offense has occurred, particularly in these situations, how or what factors do you consider when determining whether somebody's a primary aggressor?
Usually based off of testimonial and also any other evidence such as markings or, in this case, video, audio. These are all the things that I take into consideration.
Okay. And what does it mean, I guess, for an offense to be kind of a family violence offense?
Usually it's a spouse, ex-spouse, other family members, and they have to commit the crime of simple battery, cases kind of like that.
Probably an obvious question, but in your determination of what occurred on April 8th, did you consider it to be a family violence offense?
Yes, ma'am.
And who did you determine to be the primary aggressor in this case?
Mr. Michael Boggs.
Okay. And kind of reiterating the reasons why, I know you kind of said it before,
Yeah.
but the audio recording.
Audio, testimonial. Yes, ma'am.
I'm going to show you what has previously been referenced as State's Exhibit 3.
Thank you, ma'am.
What is that?
This is a bail order.
Okay. Does it seem to be, I guess, an accurate depiction of the bail order as it applies to Mr. Michael Boggs?
Yes, ma'am.
I know this is probably a question for my morning stream and not my night stream, but in Australia, do you eat Vegemite on crackers as well, or just on bread? And is it always on toast, or is it on bread?
Does it seem to be, I guess, modified in any way?
No, ma'am.
Your Honor, I'd move to admit State's Exhibit 3.
It's admitted.
Is it signed at the bottom?
Yes, ma'am.
That signature line is labeled as what?
Defendant's signature.
And it is signed?
Yes, ma'am, it is.
Is it dated?
Yes, ma'am.
Your Honor, what is...
Bill, how do you eat your Vegemite? Oh my gosh, CJ's here. CJ, can you answer my question? Do you guys ever eat Vegemite on crackers or just on... I still have one left. CJ sent me that. CJ sent me that. I tasted the other one, but I don't really remember. It was so long ago. But, alright, I'm going to put it on crackers right now. I'm going to do it. A thin layer, right? Don't goop it up. Just a nice thin layer, right?
Does this have to do with the actual case? What?
Relevance, Ms. Williamson?
Yeah, relevance, please.
I'm kind of getting there with this particular witness as to his personal knowledge of whether or if he has any concerns about the parties having contact after the offense date.
Okay, I'll allow it. You can ask the question.
I'm sorry.
I have butter.
So defendants,
We've not already got there, like I admitted to it. But I came in
I've
with-
overruled your objection, Mr. Boggs.
I'm sorry, I don't mean to be disrespectful. I feel like we're still wasting. Go ahead, I'm sorry. Please.
You can proceed with your questioning, Ms. Williamson.
You indicated there is a signature line, defendant's signature, and it is signed, it is dated.
Yes, ma'am.
And the date was again?
4/19/2025.
Okay. And the conditions of that bond in relation to contact between Michael Boggs and Alicia Boggs is what?
It says here that they shall have no contact directly or indirectly.
Okay. And since you've been in the courtroom today, have you personally seen Mr. Boggs have contact with Miss Alicia Boggs?
Yes, ma'am.
And what was the nature of that contact?
He was asking for a cigarette.
Okay. And earlier when you were out in the hall, I guess waiting to be called as a witness, do you have any kind of concern
And then he stole her whole back.
about the parties having contact?
I do.
And why is that?
When I saw Miss Boggs leave the courtroom going out in that direction, shortly thereafter, I saw Mr. Boggs leave in that direction, and he came back with a set of keys that I did not see him leave with.
Okay. And so they kind of left in the same direction?
Yes, ma'am.
During, like, I guess, a break?
Yes, ma'am.
Okay. 1 second. I believe those are all the questions I have right now.
Cross-examination, Mr. Boggs.
Yes, Your Honor. How are you doing today?
Doing well, sir.
I'm not going to take too much of your time. I'm not upset. You're a young man. You're doing the best you can. Fantastic. When you heard the audio evidence, okay, let me take it back.
I really like it. It's salty. I really like it. I really like this food. Vegemite with butter on crackers. It's it's yummy. I think it's good. It has a great taste. 10 for 10. I'll eat this.
So you went through schooling and things of this nature. I heard you went like detective, and so you're pretty good at this thing, right? Like you probably take a lot of calls. You go out, and this is kind of a normal thing, correct?
Yes, sir.
Like domestic violence and things of that nature.
Yes, sir.
Now, would you say that most domestic violence is a multiple? Does it happen multiple times in each family? Do you think, in your opinion?
I don't.
Like, if you go to one house and you run their name, is there normally a prior on there for other violences or violence in the family?
Every situation is different. I can't speak on.
Okay, fair enough. You know what? That is absolutely plenty. One other question. So when you heard the audio, are you aware of AI?
Yes, sir.
And how it's came along very quickly?
Yes, sir.
Okay. And you know what? I'm not gonna
That wasn't me. That was AI, sir.
say, I'm not turning on my family or God. Thank you, officer. No further questions.
Yes, sir.
That's it.
Any redirect?
No, ma'am.
All right. Any reason why Deputy Cochiola cannot be excused?
He may be on call.
Okay. All right. You're on call.
Thank you.
All right.
State rests.
Okay. All right. The state has rested their evidence. Mr. Boggs, do you wish to present evidence?
Absolutely not. I can just say that everything you've heard was true, and
Okay, hold on. I feel like you want to get into your closing argument, which I'm going to let you do in just a minute, but did you want to present any evidence either by way of testifying, which you don't have to do, or
Are you talking about Mr. Kelly? Because he is one special dude.
anything? Did you want to present any evidence?
yeah. No, let's just rest this.
Okay. All right. Do you need more time to think about that decision?
No, absolutely not. Absolutely not.
Okay. All right. So now the lawyers are entitled to a brief conference with me to discuss the law I'm going to give you before we go into closing arguments. So I'm going to take about 5 minutes to talk to the lawyers about the law that I'm going to give you, and then we're...
So I have a bonus for you then, Sherry, that you're going to love. You really are. So, Mr. Kelly, I should probably get the link if I'm gonna talk about this. Mr. Kelly and Mrs. Hetzler, Cindy Hetzler, we here at Court Vibes have been watching them for a while. And I have a playlist just for him. Hold on, he has multiple. I'm looking. I think it's called The Craziest. What is it called? Don't I have a playlist for him? Oh, I have so many playlists. I'll find it and I'll add it. I know I have a playlist for him. So you can watch. So when he first started that case, he was absolutely crazy. Like, it sounded like he was way far in left field. There it is. I found the playlist. Now I just have to get the link to the playlist. I think this is the link of the playlist. If not, then I failed, and you can just go to my channel and go to playlists, and it's called The Worst Pro Se Ever. I have 1, 2, 3, 4, 5 videos of him. Guys, this is the one with the mason jars. Do I need to say more? Have fun. Sorry, back to work.
We're going to do closing arguments. All right, so y'all take about a 5-minute recess. Mr. Robertson, if you'll bring those documents to the well of the court.
Does either side need the charge conference taken down?
Don't go anywhere.
Yes, ma'am.
All right, everybody have a seat. Mr. Boggs, I want to talk to you just a little bit more before we go on, because I really want to make sure that we have enough time to talk about this and you have enough time to make this decision, okay? I'm going to ask you some questions, and it's going to seem like I'm asking you the same question over and over, and I'm not trying to be tedious with you. I just want to make sure that you've had sufficient time to think about this, okay? Whether or not you testify in a case in which you are criminally charged is an important decision. Do you understand that you have a right to testify, and that if you want to testify, that no one can stop you from testifying? You do? Okay. Do you understand that no one can make or compel you to testify?
Yes, ma'am.
Okay. Do you understand that it is totally your decision about whether or not you testify?
Yes, ma'am.
Okay. Do you understand that if you choose not to testify, then upon a proper request by you, and even without a proper request by you, I'm going to tell the jury they can't hold that against you? Do you understand? Okay. If you were to testify, you understand Ms. Williamson would be able to ask you questions?
Absolutely.
Okay. Do you feel like you need any additional time to think about whether or not you want to testify?
No, ma'am.
Okay. All right. So your decision is...
What is his decision? Is he going to testify, or is he going to keep quiet and be smart? You know, like when you're about to go to jail, get a lawyer. That's that kind of smart. Or is he just going to testify and tell us everything about his criminal past, and that he's high right now? Who knows what he's going to say if he would testify? If he's going to bring up the time where he beat his child and then said, see, I didn't do that to her, and that proves I didn't do it, because I would have done it, because look, I did it before. Just kidding. He never did that before. Never did it. But if he were going to testify, that would be something that would come out of his mouth. We're just giving the poll another second to close. I can't really see how many people nope, I can't see how many people voted, so I don't really know if y'all did or not, but I'm going to end the poll. So, yes, 60% of you think he's going to testify. 10 votes. So 6 people, look how good I am at math. 6 people said, oh, yes, he's going to testify. 4 people said, nah, he ain't going to testify. Except there's 21 people watching right now. So some of y'all didn't even have a vote. Here we go.
What, to testify or not testify?
No, ma'am, I do not feel like I need to testify against my family or God.
Okay. All right. So here is the law that I plan to give.
He did not testify. Is that not crazy? We all expected it. Even the ones who said no weren't going to be surprised if he did say yes. However, all 6 people who said yes are shocked right now, including me. I can't believe it.
I didn't have any requests to charge necessarily. You may have filed them, Ms. Williamson.
Were they not?
They may, I don't know.
Do you want a copy just in case?
Yes.
See,
Just
look
in
at
case
my
there's
phone.
something that you feel strongly about.
Shocked.
This is law.
This is the law.
Y'all might as well keep it. I ain't seen no law to send it
I
down.
gave him a copy of my jury charge.
Okay.
Not y'all, I'm sorry for y'all, but
File mine,
yeah.
this morning.
Okay.
Notice how every time he says stuff like that, he always looks around to see who's watching, who's paying attention. He's just trying to get attention.
And they may have been filed, they just didn't make it to me.
Oh, better.
I'm sure they were. Ms. Williamson, I'm just going to run through yours. 1, 2, 3 is in there. 4 is in there. Evidence generally is in there. I didn't charge on to direct and circumstantial because I just didn't really feel like it was a circumstantial evidence case, so I just left it out. Do you have a strong objection to that?
No.
Okay. Credibility of witnesses is in there. I didn't do witness impeached, but I did prior statements. I don't think witness impeached is in there.
Would it be, I think there were things that she indicated, well, it is more prior statements. It is more prior statements.
If you want witness impeached, I'll give it, but I'm just going to read it. I'm not going to give it to him. I don't have the bandwidth or the ability to retype it.
Okay.
But I do have prior statements in there. Single witness corroborations in there. Defendant's choice not to testify is in there. Prior difficulties, I did not put in there. Of course, I do think there have been some, but I
would just
didn't
ask
charge
that you
them.
read it.
Thank you, V. Thank you so much. Don't worry, I cut out all the jury instructions. Don't worry, don't fret. No fretting.
Your Honor, also, that December 17th case that we can't seem to find any paperwork on, I'm almost positive that there was a signed paper also stating that we would not have any violent contact.
I don't know what December case you're talking about, Mr. Boggs.
The December 17th was the time that I was telling you that I came in and talked to a different judge, a male judge, and I had a lawyer at the time. And
How many of you accidentally say December in your natural life because of watching too much Georgia courts here in Court 5s? Not December, December.
I'm just saying that that was the paper that I filled out, and also I'm sure my phone number is definitely on there, and my email is definitely on there.
Okay.
But as far as like a house where I could, I didn't have one. I was in the process of moving, but we'll get into that. Like, I don't know. Man.
Just like
Intent, I
you
gave.
didn't have a working car, but you needed gas money. Like that kind of situation?
Venue, I'm giving. Verdict is in there. Court has no interest in the case. Sympathy's in there. Sentencing responsibility for is in there. Deliberations is in there. Unanimous verdict is in there. Simple battery is in there. And I gave a charge as to family violence specifically.
Thank you, I forgot that.
And disorderly conduct. So the only one that I think you really asked for that I didn't have in my written charge is prior difficulties. And I also did not specifically charge them about prior difficulties when any came in, but I mean, maybe it was just kind of part and parcel of her testimony. I didn't specifically hear any specific instances of prior difficulties, but I think she just sort of talks about their relationship generally,
She was
probably.
asked if this was the worst, if there had been priors, and she indicated during their marriage, and she indicated nothing like this, pushing and shoving.
Okay, I will give that. Okay. Do y'all need some time to set up before closing?
Micah, who are you talking about?
I I know you would rather probably not close tonight, but I want to keep going.
I know, and I'm fine with that. I can swing it.
Okay. All right.
Who was the Belgian? We had a Belgian that came in to our stream often a while ago, and he introduced us to, are they quacks? Is that the beer? It comes in this like tube with a bubble on the bottom. Quacks? Quack beer? Quak? Is that right? What was his name? I can't remember his name. I think he also went to the OJ trial for a bit too.
So, this is the law that I'm going to give that I have, this is the law that I'm going to read to them. But I don't read them to law until y'all give your closing arguments. Ms. Williamson has the burden of proof. She's the state. She has the burden of proof, so she gets to go first and last if she wants to. Do you want to go first and last or just last?
First and last.
First and last. So the way it's going to work is you can have up to 30 minutes each side for closing arguments. She'll get to talk first, you get to talk. Because she has the burden of proof, she gets the last word, and then I'll read them the law, and then they'll go deliberate. Closing arguments is your opportunity to tell the jury what you believe the evidence has shown or not shown. And this is the, this is the part where you're allowed to argue. Okay?
I think I'm almost done arguing at this point.
Okay. All right. So this is your chance to persuade the jury to decide the case in your favor.
It's exhausting. It doesn't matter which way it goes at this point. I don't care.
Okay. All right. Is everybody ready to proceed?
Yes, ma'am.
All right. Let's bring in the jurors.
Okay.
All right, everybody may be seated. All right, members of the jury, now is the time during the trial for both sides to give what's called a closing argument or a summation. We talked about this when I gave you that brief recitation of the law and the trial procedure. Because the state has the burden of proof, they get to go first and last. And so my understanding is that Ms. Williamson is going to go first and last. And so at this time, I will call upon Ms. Williamson to give the state's closing argument. Do you need the
I do not.
Okay.
Normally, I would have a beautiful PowerPoint for you, but I don't. So I'm going to do this the way I used to do it for a decade as a defense attorney. So in this case, what I wanted to do in my opening closing, because I get an opening closing and then a closing, but what I want to kind of remind you, because you've heard a lot, you've had a lot of information kind of thrown at you, is what are you actually here to decide, right? And so at the beginning of voir dire, the judge indicated what the charges you're here for are. And you're going to have a copy of this accusation in the deliberation room with you. But essentially, what you're trying to decide is whether Mr. Boggs is guilty or innocent of simple battery, family violence, whether on or about April 8th of 2025 did intentionally make physical contact of an insulting or provoking nature, to wit, grabbing Alicia Boggs, bless you, and pushed her against the wall. Said person being the former spouse of the accused. That last language being the former spouse of the accused, making it that family violence as we talked about. So simple battery, there's a reason why I specifically asked if she had any marks on her person. Simple battery does not require marks, right? It is just a insulting or provoking touch, essentially. And so in this case, that is him grabbing her by her neck and pushing her by her neck. Count 2, which you are to decide, is disorderly conduct. Same thing, on or about April 8th of 2025, did act in a
He's too young for you. T.
tumultuous manner toward Alicia Boggs, whereby said victim was placed in reasonable fear of her safety by yelling and grabbing at Alicia Boggs, which I guess you could interpret as him grabbing her neck, him pushing her after grabbing her neck, putting her in fear enough where she fled to her car, called 911, and then went to a church up the road to further get away from him. But that is a law that you are to decide. It is not, did or did he not steal $100 out of her purse? It is simply, did he commit a simple battery, family violence, and was he acting disorderly on this particular day? I will come back later with argument. Thank you for your attention.
All right, Mr. Box.
Wow, I kind of get it now. Like, if you're going to be your own attorney, definitely don't do it on a domestic violence or a family case. I'm exhausted. You've got all the evidence.
Monica, thank you for the cheers. Thank you.
You've got two people that are fighting against the state at this point to not let them crumble our family. And yeah, I made some mistakes and she made some mistakes, but to tear us apart, like, it's not gonna happen. It's just not gonna happen. If it's the law, then yeah, sure, I'm gonna abide by the law the best I can. But you really gotta ask the question, like, what is the...
All right, Micah, but what kind of shoes is he wearing right now? Like a rough and beat up pair of Timbs, or sneakers, or a nice pair of dress loafers?
motive here? Well, I mean, what is the motive here? To keep a dad from, what, interacting with a mom so that we can keep the kids, like, mentally okay? Like, we both need each other. God knows my kids do not just need me. And they don't just need her. But for 9 months, that's what they got. One or the other. For 9 months, we weren't able to build with each other, to help each other with cars. Did we make mistakes? Absolutely. We got heated. We yelled at each other. We did all kinds of stuff. At no point did we ever intend on hurting the other one. We could. She's also athletic. I know. I said she was a captain of the cheerleader squad. If she wanted to hurt me, she could. Women have the power to bust my nose and everything, and they may not win. And she may win. She's an intelligent girl. We get along. But we're just not. That ain't what we are. We're just not. I mean, all of y'all been married. Y'all know what it is. I'm sorry. I'm sure y'all make the best decision.
Here we go, Michael. Here we go. Here we go. Here we go. Oh, that's rude. We don't get to see what kind of shoes he has on. Rude.
Ms. Williamson, are you ready to proceed?
Yes, ma'am. I think I'm slowly losing my mind. I did make a PowerPoint.
Oh, okay.
I'm so sorry. Would you just be my clicker? Thank you.
Are you ready for me to put it up?
Yes, ma'am.
Good.
Okay. Very quickly, I want to review the evidence. Obviously, she was married to him for years. They have 2 children. Not to follow the white rabbit down the hole. But whether a defense attorney or whether a prosecutor, having done it now for over 10 years, I do it because I care for people, right? You would have to some degree or another. And so it is not the state coming to ruin his family. It is not the state coming to ruin his life. For better or worse, decisions were made, not...
That's how I try to find boyfriends. I ask them if they'll be my clicker. If they say yes, fine, they're in. If they say, what are you talking about? Then I move on.
By the state on April 8th by Badmaster Box. And unfortunately, when a crime is perpetrated, you nor I nor the state just look away. I mean, there are laws in place for a reason. We should be able to go on about our lives, whether it be Miss Boggs or anyone else in society, feeling safe to do so. And regardless of whether you're driving and somebody cuts you off, regardless of, interpersonal relationships and not getting along with one another, never ever is it okay to lay your hands on another person. And that is the issue that I have. That is why I've continued to prosecute this case. Because this wasn't the first time. As she indicated, there was pushing and shoving in their marriage before. And unfortunately, in that cycle of violence that occurs, it can escalate. And it can be dangerous. There are certain lethality factors that we know about as prosecutors, as criminal attorneys, as litigators in criminal cases that we see over and over again and that we have to consider, right? One of those is putting your hand around somebody's neck. A lot of times people want to argue, well, the state overcharges people and they're overbearing and I'm a bully. That is not the case. Strangulation, that is a more serious crime. That is called aggravated assault. Aggravated assault can also be charged in a way where hands can be offensive weapons, but he is not charged with that because she testified or she gave information to the officer that she could breathe, there were no marks. And so here we are with a simple battery family violence, but that does not make it any more dangerous. It does not make it any less important.
Martha, thank you so much for the PayPal tip. I really, really appreciate it. You're the best. Thank you.
To hold him accountable for his actions. It was notable to me that the two of them consider their relationship brother and sister. Because when I think of brother and sister, sure, as children, you might push and shove your sibling, you might pull their hair, you might do some really...
Oh, I did worse than that, let me tell you.
evil stuff to your sibling. But when you're an adult, when you know right from wrong, it's different. Your adult brother doesn't put his hands around your neck. Your adult brother doesn't say, respect me in my house before he bows up at you like he's going to hit you. Not an adult brother who's thinking of the consequences. You shouldn't, I'm sorry, go back a little fast. You shouldn't have to record interactions with people simply because you're in fear. I do not doubt for 1 second their fondness for each other, their wanting to support each other. But again, that is not a justification. It is not a let me erase what you have done. It doesn't take that away. But unfortunately, she did feel the need to record. And that recording is very telling. It is hard to listen to over and over again. But I think it is very telling on who the aggressor was in this particular case and who escalated this argument into a physical altercation. Yes. So you have the body cam, you have the recording, and you have her written statement. There are certain things that unfortunately legally cannot go back with you to the deliberation room, and they include those things. So you, as a jury, can request to see those items if you so choose to review them. Things that have been admitted into evidence. So I won't necessarily beat a dead horse and go over those things again, but if you feel like you need to in your deliberations, you can request to do so. But I think she, for better or worse, is trying to mitigate the situation months after the fact, and blaming herself and wanting to say that she has a bad memory, and wanting to talk about alleged drug use. But in watching that body cam video, she seems quite with it about what occurred. And her memory is not spotty. It is not lacking whatsoever. Just take it out.
Objection, Your Honor. How does she know it's a... Continue, please.
And then thinking further through the evidence that has come out,
Oh, Sandra, I'm
I think
sorry.
Mr. Boggs has taken on this trial. I'm not sure exactly what he expected the result to be, but I think he is apologetic. I think through
Objection,
his
Your Honor.
alleged questions.
I already told him no objection. I'm not apologizing. My family doesn't need that.
Okay, so members of
sorry.
the jury, you'll recall
I am absolutely not apologizing, Your Honor. Objection.
what the evidence has been. What the lawyers say in closing arguments is not evidence. And-
Oh, I'm sorry.
Okay, Ms. Williamson, you may continue.
Not evidence,
But it is-
argument. I think it is notable that when questioning Ms. Boggs, he asked, haven't I apologized to you? Take that for what it is, but it doesn't simply take away what he did. It's not whether he's a good dad. It's not whether he apologized. It is, did he put his hands around her neck? Did he grab her? Did he commit a simple battery? Was he disorderly? I would submit to you that he was. And I am going to ask that you find him guilty of both counts. Thank you.
All right, members of the jury, I'm going to give you the law now. You will have a written copy of the law with you, so you don't have to feel like you have to write anything down or take notes. Just please hang in there with me while I read you the law. You may now retire to the to the jury room, but do not begin your deliberations until you receive these documents, the accusation and any evidence admitted in the case. You may now proceed to the jury room to select a member to act as foreperson. All right, I need Ms.
Let's do another poll.
Hickman,
Is he
please.
guilty or
Can I get Ms.
innocent?
Hickman? I think it's Ms. Hickman.
Is that to go to him?
Yeah. I need the alternate.
Yeah, Bobby,
Juror
thank you.
number 55.
55. Your Honor, is this considered a break?
No, not yet.
Your Honor, I need to go to
Ms. Hickman,
that.
you may have done some quick math and figured out that there were 7 jurors in watching the trial, which means you are the alternate juror, just because you were the last one picked in order, which means you don't get to deliberate with the others unless and until something happens to one of the others. So what I'd like to do is place you on call, let you go about your business, and we'll only call you if we need you. Okay, if you'll just give your number to Mr. Reeves, I'll let you get out of here, okay? Just don't discuss the case till you hear from me, okay? All right, any objections to the charge as read or the procedure with alternate?
Last chance to
Ma'am,
vote.
any objections
Last
to my
chance to
legal
vote.
charge, Mr. Boggs?
No, ma'am.
Okay, and to answer your question, now we're in recess, but you just don't go far, because they may have a question or they may get a verdict, okay? But you can, if you need to go smoke a cigarette or something, you can step out.
Thank you.
Okay.
Don't ask her for another cigarette. The police are watching you.
Completely off topic. Brett Turner texted me.
At 6:30.
Yes.
Okay, we got 12 votes this time. Guilty. Everybody thinks he's guilty. I'm not counting the other votes.
All right. Now, before you bring in the jury, I just want to talk. Okay, are we back on the record? Do I have Sharon?
Yes, Yes, ma'am.
All right. Before we bring in the jury, I just want to put on the record, I have been notified by my bailiff that the jury has reached a verdict. To everyone in attendance, I realize that criminal trials can involve all sorts of emotions for everyone involved.
I want everybody in the chat to listen to this and behave. Here we go.
However, in the courtroom, we can't have an emotional reaction to the verdict that is audible or disruptive.
Don't start crying.
Therefore, I'm advising anyone or everyone in attendance not to have a reaction when the verdict is published. And anyone who does will be escorted out of the courtroom.
It wasn't long. It wasn't like hours or the next day. This is the same day. If I had to take a wild guess, 40 minutes maybe?
Until they can regain their composure. All right, thank you for your cooperation on that. All right, at this time, let's bring in the jurors.
I ate it all. Sorry, CJ. Yeah, I already did, T. I already did. I took the tip that Martha gave me and I put it on his books. Wish me luck, guys.
Y'all can have a seat. All right, Ms. Pfeiffer, if you'll remain standing for me just a moment, y'all can have a seat. Ms. Pfeiffer, I understand you are the jury foreperson, is that correct? Yes, all right. I have been notified by my bailiff that you all have reached a verdict, is that correct?
Yes, ma'am.
And was it unanimous?
Yes,
that means, okay. And has the verdict form been filled in, signed, and dated by you?
Yes, ma'am.
Would you hand it to my bailiff, please, and have a seat? Thank you. Mr. Reeves, if you'll hand it to me.
There's a bailiff getting ready.
All right. At this time, I'm going to publish the verdict. In the Court of Hall County, State of Georgia versus Michael Shane Boggs, case number 25 SR 5083. Jury trial verdict. Count 1, simple battery, family violence. We, the jury, find the defendant guilty. As to count 2, disorderly conduct, we, the jury, find the defendant guilty. This 31st day of March 2026, Denise Pfeiffer, foreperson. Madam Clerk. All right, members of the jury, at this time, your service in this case and for the week, right?
Yes.
For the week is concluded. Ms. Pfeiffer in particular is pumping her fists.
They're saying that because I think remember we did another trial? Yes, 2 days ago. I think they did trials all week, this poor jury.
I appreciate your time and attention. I did not intend to keep y'all so late, but it was important, given the volume of the cases we had this week, to keep pushing through. We have 2 more trials behind this one. So I certainly appreciate your time and attention and your service in this case. It is my plan to go directly into sentencing. You all probably want to leave, but if you want to come back in the back of the courtroom to watch sentencing, you may. Normally, I like to try and go back there and answer any questions you have, but given the hour, I won't do that. But you will receive a letter of thanks from me in the mail, and it'll have my email and my phone number if you have any questions or comments about, or feedback about your jury service. But with that, the check is in the mail, right, Sharon?
Yes.
Okay, I'm going to release you, and thank you for your
Their
service.
check is in the mail, Bobby. They're getting paid. What, $15 or whatever?
All right, everybody can have a seat.
May I be excused?
You may be excused. Thank you, Ms. Fuller. I will need to probably gather whatever evidence is up on the witness stand when we conclude the sentencing. All right, I'm going to be to hold a sentencing hearing at this time.
I mean, he admitted he did it. He admitted he did it. He admitted he did the act. So, I mean, it's not surprising that they all found guilty.
What's the state's position about merger? Jerry, I need the accusation back from where the jurors had it.
Did you say murder?
Merger.
Oh.
Did you say murder?
I mean,
Josh, you missed it.
the
I
main
just ate
difference I see
Vegemite
pushing
right
her
here
against the
on camera.
wall
It was delicious.
is kind of an element
Very salty.
that is not included in the disorderly conduct.
Thank you. Thank you, Mr. Reeves.
As well as, I guess, the element of being placed in reasonable fear of your safety is not something that is necessarily required in a simple battery family violence.
Okay.
So I don't necessarily think that they would merge.
Okay, because the disorderly conduct is for yelling
And
and
grabbing.
or grabbing.
Yeah.
Okay. All right. All right, so anything you want to present in aggravation or mitigation?
In trying to, I guess, resolve this case, my last, I guess, amended offer was a bit more lenient. And then after is when I watched the body cam in this case, which is what led me to have kind of a concern about mental health, being that she indicated he is bipolar. Now, do I know if that is a formal diagnosis? I do not. But I do know that people who use substances normally can be self-medicating. So it did make me wonder and be concerned about that particular aspect. And in talking to Ms. Boggs, she, again, like I've mentioned, was very forthcoming about the fact that she has had issues. When I specifically asked her if Mr. Boggs has had the similar issue, she did indicate she is not sure. But at the same time, I'm not.
So a lot in Georgia lately, we've been hearing a lot of these cases where the jury is absolutely not allowed to think about what sentencing might be while they're coming up with a decision. And I remember that in the OJ trial too. You're not allowed to think about what the sentence might be. So they are definitely not a part of the sentence, so much so that they're not even allowed to think about it or talk about it. So they can't talk to each other and say, oh my gosh, if we do this, this is going to happen to this guy. If we do this, this is going to happen to this guy. They're not even allowed to talk about that. But then other cases we see the jury picks the sentence too. I don't know what the pattern is. I don't know if it's by case, by state, by judge, by county. I don't know. Tomorrow we're going to see another trial, but this is civil. It's brother versus sister. They're two lawyers. And the jury has nothing to do with the verdict there as well.
Exactly convinced, given the circumstances, and looking at his criminal history, as she was trying to, I guess, mitigate the situation for him kind of all along, Your Honor. But as it pertains to his criminal history, it does date back to 1999. His more recent history that I think would be pertinent.
I would like to hear a complete.
All of it?
Complete criminal
Yes, ma'am.
history.
I just didn't want to
I
go too
know.
far. So in 1999, he had a DUI to which he pled guilty. In 1999, he pled nolo to a misdemeanor obstruction. He's had a couple probation violations. In 2000, he pled nolo to driving while license suspended. In 2004, he pled guilty to carrying a concealed weapon, nolo to a misdemeanor obstruction. And then this is interesting. So it has forgery in the First Offender Act in 2005. It says First Offender Act discharged in 2011. In that same cycle is a simple battery to which he pled nolo in 2005, but it does not say that that simple battery was also covered under that first offender. It was just under the forgery. He pled nolo in March of 2005 to a disorderly conduct. Nolo in 2007 to driving while license suspended. pled guilty to a misdemeanor obstruction in 2021. It looks like 2 counts. The original indicted charges being hindering the apprehension or punishment of a criminal in possession of a Schedule I or II controlled substance, but then they were pled down to misdemeanor obstructions in 2021. He pled guilty in 2023 to driving without a license. He has the case in White County, which was a theft by receiving stolen property that occurred in May of 2021.
Is that a misdemeanor or a felony?
A felony. And then this case, and after this case, he had his probation violation.
Okay. So am I understanding you correctly that there's a giant gap in his criminal history between 2007 and 2021 where there's no arrests? Because it's like there's a ton of arrests between 99 and 2007, and then everything.
So in 1999, as I mentioned, a NOLO to an obstruction. In 2000, he had a probation violation. Again, in 2000, he had another probation violation.
But
And then he pled NOLO in 2000 for driving while license suspended or revoked.
Right, but there's nothing in between?
No.
2007 and 2021?
Those, okay, so since 2000,
Because the driving while suspended license, you said was 2007. He completed the first offender of probation on the forgery in 2011 from a 2005 arrest. You
so
said.
from 2000, driving while license suspended, he had a failure to appear in 2001. There was an arrest, but not a conviction back in 2001. It was a dismissal, so that's why I did not mention it. And then he has the NOLO in 2004 to a obstruction misdemeanor. And then after that, he has the guilty to carrying a pistol without, well, that was the carrying a concealed weapon.
That was '04. All of this is when Mr. Boggs was really young.
And then in 2005, the simple battery, and then he had another case, but the charges were dismissed in 2006. And then the NOLO in 2005 from the original 2005, a disorderly, which was the original charges, it says, at a Duluth Police Department was carrying a concealed weapon, manufacturing some type of drug, possession of a sawed-off shotgun. But ultimately, that pled out to just a disorderly conduct, to which he pled NOLO in 2005. And then in 2007, driving while license suspended.
And then nothing till the obstruction in 2021 is the next cycle.
Correct.
Okay. I was just trying to understand that. Okay. What's your recommendation?
12 months probation. 30 days in custody. I still stand the same way I did before, in the fact that I'm not so much concerned about him paying a fine or money. A mental health evaluation to comply with any recommended treatment. A drug and alcohol evaluation to comply with any recommended treatment, no drugs or alcohol screens. No violent contact with Alicia Boggs. The disorderly 12 months probation, run consecutive, all terms carry.
All right. Anything else from the state?
No, ma'am.
All right, Mr. Box.
Yes, ma'am.
What do you want me to consider?
So, you was asking about the gap. I had kids. I changed my life around. When I started getting back in trouble, I went through a divorce. And, I mean, you see, I'm actually, I don't really, kudos, you know, I try my best, it is what it is. But as of tomorrow, I'm finally back on my feet again. I don't want to ask that, you know, I'm not one to beg. I would do this over again.
What's happening tomorrow?
Tomorrow I get paid for, so I'm taking care of an older lady in Canton. She was going through some rough things, and I did work on her house. I'm staying there. So she's about to pay me. I've got 2 trucks that I have hustled up in order because I can't work until I get a vehicle.
Mm-hmm.
So I got the money coming in to finally get the vehicles running. I work on cars. And I'm also, one of those vehicles I'm giving to my son, which has had hard times. He just got out of jail. My other son's at Walmart. He's finally got a vehicle. Like, all I would ask is, you know, I understand, like, you won the case. Just the 30 days. The 30 days, if you want to tack on some money or whatever the case may be, I just feel like the 30 days is not going to help. I've done plenty of time. It's not the time that makes me be good. It's my family.
What kind of, have you always done like construction type work or mechanic type work? Or what kind of work have you done? Because you were telling me you hadn't worked in a while.
UPS. I was a UPS driver for 8 years.
Okay, when was that?
2013 to 2020.
Okay. What happened?
That's 7.
Divorce.
And?
Like I told y'all, like,
I want to understand, Mr. Boggs, and I want to
Maybe his social was on the dark web and he's just too scared to admit it. That's why
be
he can't work.
thoughtful
no, you are, you're fine.
about what
So
I do here.
I was, so I coach my kids.
I don't want to pry, and you don't have to tell me.
No, you ain't got to pick. Just try not to damn tear. No, I'm sorry about cussing. Try not to tear up. So I coach my kids through everything, and it's like when you only get them like once every 2 weeks, and you go from dropping packages off at your house. It is what it is.
But you had custody of your son some of the time, it sounded like. Or at least what came out in the trial was that you had Chance living with you some of the time?
Yeah, that was afterwards. So that was after he grew up,
Okay.
and I had gotten out of jail for the
I'm interested in doing this 2 weeks, once every 2 weeks with my own children right now with their adults. So I'm interested in this. Tell me more.
felony. The felony was actually a U-Haul already, and I was homeless. I had nowhere to put it.
And so that was the theft by conversion because you didn't return it or something?
Correct. I had stayed in contact with them, but Gwinnett County dropped it. It was in White County. The vehicle was fine.
Okay. Again, you don't have to answer this question if you don't want to. I'm just trying to make sense of everything.
Yes, ma'am.
Do you have a substance abuse or a mental health issue that you have recognized or been diagnosed with?
I mean, no, it's obviously not. If I can hold a job for 8 years, if I can keep myself from making decisions that, like, felonies and things of that nature. Like, I grew up on Jimmy Carter, Buford Highway. I grew up in a rough area. But I didn't choose that path. I mean, everybody here they may think different, but from where I grew up, I didn't.
And I ask this question, you know, there are people who go to work every day and hold a job and look like real functional members of society that are functional alcoholics, right?
45 years, and I have had multiple interactions with the police. So many interactions with the police. They look at me. I mean, I know I got a sweater vest on now, but you know, you can hear it in my voice.
He has a sweater vest on? Get the hell out of here. Guys, does he have a sweater vest on? Am I crazy? Dude, I don't think that's a sweater vest unless I am just blind as a bat.
They search me every time.
Harassment.
I've been on multiple probations.
That's harassment.
No failed drug tests. I smoke some weed, but I don't even smoke weed anymore. I ain't smoked in over 2 years.
It's a sweater, but it has no sleeves. Okay, so you wear a shirt like this button down, you'd wear under it, and then you would wear a sweater vest on top. It just covers your torso, but not your arms.
Smoking weed.
Okay.
Like, so.
Okay.
Do I have a mental like? Not one that I get violent with people. Not one where you like.
And I'm not saying, there's lots of people who have mental illnesses that are not violent at all. That's not what I'm asking.
Right.
I'm not saying that.
What kind of mental illness, like?
They're asking for a mental health evaluation,
No,
and
I understand.
I'm just asking you whether you've ever been diagnosed with anything.
No, I've never been diagnosed with anything.
Okay.
Yeah, no, I've never been diagnosed with anything. My dad was fine. My mom had issues, but not crazy issues. Like, my life is good.
Okay.
So, no.
Okay. All right. All right, Mr.
Exactly. Identical.
Boggs,
Same word.
you can remain seated,
Yes,
okay?
CJ.
The first thing I want to tell you before I forget is that you have 30 days to file an appeal of your conviction if you want to file an appeal of this conviction. You have a year from today's date to file a habeas corpus action, which is a civil action, which is another way to attack the conviction.
Knitted.
It's entirely possible that you might have qualified for appointed counsel had you cooperated with the questionnaire. And you might even still, if you wanted to apply for someone to look into the appeal. The conditions of the probated portion of your sentence are going to be as follows. I'm not going to impose any kind of fine. I don't see the point of that, just like Ms. Williamson didn't. I'm not going to impose any community service. I am going to require that you complete a family violence intervention program, which is statutory when you're convicted of any kind of offense of family violence. It takes about half a year to complete, and it does cost money, but it is required by law, and I think it's appropriate in this case.
That's right.
I am going to require that you undergo a mental health evaluation and follow through with whatever treatment is recommended. I'm going to require that you undergo a drug and alcohol evaluation and follow through with whatever treatment is recommended. You can't consume.
Oof. Right there, I can't break the law, because if they ordered me to do both of those things, I would have to pay out of pocket. Ugh.
Any drugs or alcohol except for prescribed drugs while you're on probation, and you'll be subject to random screens to ensure. I'm also going to impose a Fourth Amendment waiver. It's also going to be a condition of your sentence that you not possess any firearms or ammunition. Now, I know you completed first offender on the one felony. You may be a convicted felon and may not be able to possess them anyway. But under federal law, if you're convicted of any misdemeanor offense of family violence, you may never again possess a firearm or ammunition. And it's also going to be a special condition of this sentence that you not do that. I'm going to impose no violent contact with Ms. Boggs. Miss Alicia
No
Fox.
contact, just no violence.
And I just want to caution you, Mr. Fox, I'm not saying that you would ever do anything retaliatory toward Miss Fox. But
Absolutely not.
emotions run high during trials.
There's no-
And so I want you to
Nothing wrong.
understand that if you are in front of me on a probation violation where you've done anything aggressive, threatening, or harmful to Ms. Boggs,
Right.
I would take that very seriously. You understand what I'm saying to you?
Absolutely. That's my kid's mother.
Right.
I don't attack my family, and I'm
okay.
true to that. I had plenty of ways to fight this case that I didn't do.
Okay. I want you to be clear what I'm saying to you.
Yes, ma'am. No, I completely understand you. I
Okay.
do.
All right. All right. So the sentence on count 1 is going to be 12 months with 45 days to serve. Credit for time served. He served on the front end, I think at least 5 days I saw. I think it was between April 18th.
She gave him more days than the prosecutor asked for. Prosecutor asked for 30 days. She gave him 45.
Then April 23rd, he'll get credit for all time served. Did you serve any time in White County on a probation revocation as a result of this sentence?
4.5 months, and they'll do it again. They'll take it all.
Well, they can't take it twice. They can only do it once.
Yes, ma'am.
Um,
If I go in behind the bars, though, I'm going down there, and it is so hard to get out.
Credit for time served between, I think it's, you verified those dates, I think I looked earlier, it was April 18th through the 23rd?
Yes.
Okay, credit for time served. That'll be a full reporting sentence. Count 2 will be 12 months probation consecutive, all terms carry. No
2 years
early
probation.
termination or non-reporting except for after judicial review. So if he's doing well after the first 12 months and we have a court date, I'll consider making it go non-reporting or early terminating, but I want to have a status check before we do that. Do you have any questions about the sentence, Mr. Boggs?
Yes, ma'am. So I don't go to jail.
Yes, I imposed 45 days.
But the time that I did in White County, does it?
No, I just wanted to know how much. You get credit for the 5 days you served here in Hall County. Other credit will be up to the sheriff, but generally speaking, they're not going to give you credit for what you served in White County unless they had a
But he's
hold
going
on
to
you.
lose his
Which I don't
job.
think they
Oh, wait,
did.
never mind.
And that,
Okay.
the thing is, like, I was already in there with this, but if I go to jail, they're gonna hit me with a probation violation again.
They shouldn't if they've already adjudicated you on this. They won't do it again unless there's some other violation that they're bringing you up on. Are you still on probation in White County?
Yes, ma'am, I'm there for 10 years. I took it all the way down to 18 months, and then this
Okay.
popped up, I'm there for 10 years.
So if they revoked your probation based on this arrest, they will not be able to revoke it again just because you were convicted. It's already, okay. All right, you can go with the deputies, Mr. Boggs.
So she's harsher than a lot of the people that we see who actually hurt their exes. They did strangle them. They did punch them. You know, there were marks. But then she's nicer because I can't remember. She just did something. Oh. Nope, I can't. Oh, nope. She just did something nice, and while I was talking, I forgot about it because I'm an idiot. It's okay, you didn't need to know. I'm going to remember later, and I'm going to pause this video and say it. Let's go to... Let's watch a few cases with Judge Link for a while. V said we have to get more of him, and I outstandingly agree. He's so good. So we're going to go with him for a bit.
First case is State of Indiana versus Tara Bland, 46D04-2502-CM335. Ms. Bland appears by video.
I remember now. The no violent contact. She didn't put in place the no contact order. Just a no violent contact. So she was harsher with the sentence. He got 45 days instead of 30. He's got 1 year of probation and another consecutive, so 2 years of probation. He already has 10 years of probation. So he said he got it down for 18 months, down to 18 months, and he screwed up. So he has to do it all. So that has nothing, the probation doesn't mean anything. Unless it's consecutive to his other crimes, which could possibly be.
By counsel, Attorney Dallas Coleman in person. We're here on a third petition for revocation of suspended sentence. For initial hearing. Ms. Bland, were you advised of your rights before court today?
Yes, Your Honor.
You understand what your rights are in this case?
Yes, Your Honor.
Do you have any questions about your rights today?
No, Your Honor.
What is your mailing address?
20 Indiana 46360.
And do you have a cell telephone number?
No, I don't. Not at the moment, but I'm getting one as soon as I get out.
All right. Mr. Fredoso is going to advise you of the third petition for revocation of suspended sentence.
Thank you, Your Honor. All right. The third petition for revocation of suspended sentence alleges that Ms. Bland, who was on probation, has violated the conditions of her probation, specifically condition number 1, which is to refrain from violating any laws, state, federal, or local. On or about March 21st, 2026, she allegedly committed the new offense of criminal trespass as a Class A misdemeanor. That charge is filed under cause 46 D04 2603 CM 672, and that is in this court.
Ms. Bland, do you understand the third petition?
Yes, Your Honor.
I'm entering a denial on my behalf, or on your behalf, to the petition.
I have your boss's number. I really, really do. Should I send her a text and tell her to leave you alone this morning? I will.
What's this?
I understand it. I'm not pleading guilty. I'm understanding. I understand the charges.
And I'm entering a denial on your behalf to the petition, okay?
Okay, thank you.
She's got 2 from February or March of this year.
So the other 2 revocations, Your Honor, you're speaking of?
Well, I just want to make sure that on CM 521, we're not going to see another revo petition. Or is that already taken care of?
I'm going to send a threat to CJ's
CM
boss.
520. Oh, the revo has been filed. Yeah. Okay. Yes, that was the second petition, Your Honor, was based on that one.
All right. So it looks like her other hearings are set for April 17th at 9 o'clock. Is that correct?
Yes, Your Honor.
Are you in all these, Mr. Coleman?
I don't believe I am. I'm in causes ending 200, 335, and 115. I don't know what other causes there are.
There is 672. I don't see an attorney of record in that one. That's
in 521.
And that's set for bail review on April 6th for some reason, although this is the petition based on their.
She was probably served with the warrant, and so they probably set it for
today. Okay, so we're doing bail review today then.
All right, Ms. Bland, are you going to need an attorney in your other 2 cases where you don't have an attorney?
Yes, Your Honor. I've been homeless for a couple of years, and I'm trying to get established and get housing. I have a couple caseworkers. That's why I've been trying to get my life back together, but I have no means of income right now. No, where I could afford I really don't have anybody besides caseworkers or anybody to bond me out, or to get a hold of anybody to come up and bond me out, even if I did have the.
I put an angry face on the end of it. Is that too harsh? No, that's it. Boom. I just sent a threatening text. It was threatening to CJ's boss. Let's see what happens.
The money for which I don't. For that or a lawyer.
Yeah, but every time I let you out, you get arrested.
I am sorry. I truly, truly know that I have trespasses at other places, but I literally was just going to get my prescriptions. I was having anxiety, or my printout, so I could give it to my doctor and let them know what medications
So you confessed right here, right now. Good
behavior
job.
unit hospital put me on so I could get back on my correct medicine so I could behave right and correctly and my mind could be right and clear. That's my all intentions was to go into that store, and I literally talked to the cashier. She said it opens at 8 o'clock, to come back at 8. So I walked out, and that's what I was going to do. I had no clue I had a trespassing whatsoever from there. I do have trespasses.
Stop.
Sorry, Your Honor. But I plan on getting on my medication.
Stop. Thank you.
Guys, CJ is her boss. CJ is the boss of CJ. No one else can on this earth. Come on.
I'm more concerned about the public intoxication charge in 521.
I would also note, if I may, Your Honor,
Yes, sir.
in the police report on the newest cause, the officer also notes that Ms. Bland was intoxicated. He encountered her at CVS, which is also a violation of rules of probation.
I would definitely go to AA classes if I was released.
No. That's not how it works, Ms. Bland. You know that.
Right, I would still go on my own, though.
Here's the problem. You're fine when you're sober, but you're not a very nice person when you're under the influence is the problem. Mr. Coleman.
Your Honor,
What kind of person are you when you are under the influence? Okay, I'm going to specify alcohol because, I mean, it's different with different drugs. So let's just narrow it down to alcohol. If you do not consume alcohol, just tell me way too much sugar or caffeine. Are you angry? Are you, I love you to everybody? Do you just love everybody? The next option is the same one as the second one, but do you really love everybody or whoever you're with? Do you really love them? Or are you loud? Are you funny? What? Oh, you're hilarious. My daughter got tipsy last night and came home tipsy. It was very funny. She gets talkative and I love it. I love it so much. Although I was texting her the whole time, slow down, drink water. Even though I love it so much. I don't actually want her to get drunk. But she's talkative, but she's forcefully funny. It's so great. For me, it depends on what I'm drinking. Like if it's tequila, then that's how I conceived my last child. That's what tequila does to me. If it's wine, I'm very, I don't know, thoughtful. I think I have big ideas when I don't. When it's beer, I'm just happy. I'm just a happy, relaxed person. It's very nice. It's very lovely.
Causes that I had my appearance entered in, we did have a time served plea. Obviously, that needs to be changed now. We have to include the time that she's now served. Additionally, I would request one more release on her own recognizance, and to keep that April 17th date that's been previously set.
Or does it stay on an OR release?
Your Honor, Ms. Bland has been arrested 4 times since the beginning of the year, twice in January and now twice in March.
One time they had to release me because
all while being on probation. So the state's position would be that the bond needs to be set. The state would just ask for an aggregate bond of $600 cash.
All right, all cases remain set for April 17th, 2026 at 9 a.m., including this case with the third petition. Court is going to set an aggregate bond of $600 cash. If you post that bond, Ms. Bland, and you get arrested again and you come in front of me, your bond is going to be substantially higher. Do you understand that?
Yes. Do I go to court on the 6th still?
No. That court date is vacated.
Is there any way that you could lower it? I have no one, I don't want to be a burden on my children. I am trying to get housing so I could get mentally and physically and spiritually stable, sir. Your Honor, I promise I will try my hardest to make sure that I do not drink, I do not get in,
It would work.
even come across any police officers unless I'm going to see my probation officer. I will go to AA, could it at least be reduced down to something reasonable so I could see if my child can come get it, try to come up with the means?
$600 is more than reasonable based on the number of charges you have.
I'm
that
wrong.
you can-
Jägermeister. It was Jägermeister, not tequila. It was Jägermeister. It was 1000% Jägermeister. I don't know where. I don't know why I put tequila in my memory there, but that was wrong. He's a Jaeger baby. I mean, he's a 1000% a Jaeger baby.
Continue to get arrested, so your
I
request
got
for,
arrested and the
don't
judge
argue with me, Ms. Blaine.
The judge said that they had released me before I even went to court. They couldn't even put that on my, one of the times he's talking about, they couldn't even put that on my charges because they put $300 and told me I could stay there. Then they turned around and called the police on me. So that was one that's making me.
Your request for a bond reduction is denied. You're excused.
Okay, thank you.
Welcome. Bill.
Because I believe my she wants to tell us whether she actually left the property or if she was.
The jail was broken.
That works for me.
State of Indiana versus Joshua Myers, 4604 2603 CM 750. Mr. Myers appears by video without counsel for initial hearing.
I really just wish Mr. Myers would blink just a little more often. I don't know what it is about his eyes.
Mr. Myers, were you advised of your rights before court today?
Yes, Your Honor.
Do you understand what your rights are in this case?
Yes.
Do you have any questions about your rights today?
No.
What's your mailing address?
It's 18 apartment 23 in Cherville, Indiana.
46375 is your zip code?
Yes, sir.
And do you have a cell telephone number?
Yes, sir. It's 21.
All right, please listen. Mr. Ferdoso is going to advise you of the charge and potential penalties.
Thank you, Your Honor. There is one count alleged. It's invasion of privacy, Class A misdemeanor. The charge reads on or about the 30th of March, 2026 in LaPorte County, Indiana. Joshua Myers.
He has to be so high because, like, he wide-eyed focused, and then there's this slow blink that happens. It's very, it's hard for me to watch.
Did unlawfully, knowingly, or intentionally violate a no contact order issued as a condition of pretrial release, including release on bail or personal recognizance. That is a Class A misdemeanor. It's punishable by up to 1 year in jail and a fine of up to $5,000.
Mr. Myers, do you understand the charge and potential penalties?
Yes, sir.
I'm entering a preliminary plea of not guilty on your behalf to the charge. Your bond is being set at $600 cash. That means you have to post 605 to be released on this case. This case will also track with your other two pending cases and will be set, all of your cases, on May 8th, 2026 at 9 a.m. If you post your cash bond, you can use that $600 of your bond to help you pay for and hire your attorney. If you do bond out, you're ordered to appear in person on May 8th at 9 a.m. and have your attorney hired by that date. Do you have any questions?
Yes, sir. I'm just wondering if there's any way I can be released today. I was only there to get my belongings, and I was invited.
Stop, Mr. Myers. You have the right to remain silent.
He just confessed again.
And the right
just
is
like she did.
self-incrimination. Anything you say in this hearing can be used against you. So I don't want you to make any statements that could be to your detriment. We're not going to get into what happened or didn't happen. Your request for a release OR or a bond reduction is denied. So you're excused. State of Indiana versus James Watts, 4604 2603 F6 319. Mr. Watts appears by video without counsel for the initial hearing. Mr. Watts, were you advised of your rights before court today?
Yeah,
Do you understand what your rights are in this case?
I do.
you have any questions about your rights today?
I don't.
What's your mailing address?
Michigan City.
And do you have a cell telephone number?
No, not at this moment.
All right, please listen. Mr. Fredoso is going to advise you of the charge and potential penalties.
Thank you, Your Honor.
I love his hair, though.
There is one count alleged in the charging information. It's sexual battery is a level 6 felony. The charge reads, on or about the 11th day of March 2026 in LaPorte County, Indiana, James Watts did unlawfully, knowingly, or intentionally intend to arouse or satisfy his own sexual desires or the sexual desires of another person. Touched another person's genitals, pubic area, buttocks, or female breast when that person was unaware that the touching was occurring. Charge is a level 6 felony. It's punishable by a sentence of between 6 months and 2.5 years, with 1 year being the advisory sentence, as well as a fine of up to $10,000.
Mr. Watts, do you understand the charge and potential penalties?
Yeah, I understand, Your Honor. I ain't never been that horny.
Excuse me, Your Honor, his sister. Do you mind if I speak?
Go ahead.
So unfortunately, we did what we did. Right is right, wrong is wrong. But I've been saying this for years. He really needs help, and I love you. I'm trying my hardest. I'm here, but he needs help. This is not like him. I know him. At least when he was 16, and I've been trying my hardest to get him back straight. I can't do it all on my own. He just really needs help.
So what kind of help do you believe he needs?
If he can talk to somebody, if he can go to some type of facility to get some type of help. I don't know if he needs medicine, but
Man, you better not try and put me
I don't even start.
Wait, you better quit playing, man. You trying to play me crazy?
Mr. Watts, Mr. Watts, I'm listening to your sister, please. Thank you.
I'm listening to it too. Thank you.
There's nothing I can do.
You said he was laced when he was 16. Is that what you said?
Yes.
Yes, sir.
Yes.
I was 15 and he was with his friends and they laced his weed.
Okay.
And ever since then, he has been right. So I'm trying. I'm the only one that's still trying. I'm sorry.
Well, unfortunately, I'm very limited in what I can order as a court in that department at this point in time.
It's understandable.
I can request that the jail, their medical / mental health person assess him and determine if he needs to see a doctor or not, but it's really a doctor's decision.
Right.
Your Honor, may I speak one time?
Just a minute, Mr. Watts. I'll give you a minute to speak.
Just let him talk, man. Please, just let him talk.
Me and y'all ain't about to do me.
Please, man, stop.
I got a whole lawsuit. Quit playing.
I think that was the mom. I think.
Mr. Watts, you don't have an attorney today.
Correct.
You have the right to remain silent and the right against self-incrimination. Anything you say in this hearing can be used against you, so you should not speak until you get an attorney.
Understood.
So, let me ask you a couple questions first.
Okay.
I'm entering a preliminary plea of not guilty on your behalf to this charge. Are you going to be able to hire your own attorney in this case? Because you're going to need an attorney.
I won't be able to do it, Your Honor.
Are you employed?
No, I've been looking for employment for 2 years now. I ain't had no hits, so
Are you married or single?
I'm divorced.
Do you have any children aged 19 or younger?
As far as I know of, no. The one I had supposed to die, so.
Okay. Do you own any real estate?
No, I don't.
Do you have any kind of account, a bank account, cash app, child account, or any other account with any cash balance in it currently?
No.
All right, court finds Mr. Watts indigent, appoints a public defender. All right, Mr. Watts, I'm going to set a bond for you. Today is not the hearing. Why am I frozen? There we go. Today is not the hearing to get into what happened or didn't happen or any of the facts of this case.
That's why I talked to my lawyer about.
Correct. So your bond's going to be set at $750 cash, which means you got to post $755 to be released. If you post that money, then you have to use $750 of your cash bond to hire your attorney before your next court date, which is going to be May 19th, 2026 at 12:45 p.m. As long as he doesn't bond out. Okay. I don't know what his means are, who will post bond for him or not. Okay. So, he'll be in jail as long as his bond is not posted.
Well, just, hey, Your Honor.
Yes, sir.
I tell my sister, tell my people, I tell my cousin I'm gonna miss my uncle's funeral. Just tag me and tell me I'm gonna miss my uncle's funeral.
All right, she heard you. All right, Mr. Watts, you're excused.
There's one pizza I hate. Papa John's. Can't stand it. Ugh. Can't stand it. But I grew up in the 80s. And my daughter got dinner tonight. Papa John's. So this is what dinner is. And I'm going to eat this because I grew up in the 80s, and when dinner was put in front of you, you ate it because that's what the food is that night. So here we go. I'm going to watch Judge Link, Magistrate Link, and try to get my dinner down. I am thankful my daughter got dinner tonight. Yes, I am.
All right, please listen. Mr. Fredoso is going to advise you of the charges and penalties.
Thank you, Your Honor. There are 4 counts alleged in the charging information. Count 1 is intimidation as a level 6 felony.
Intimidation.
That count reads on or about the 30th day of March 2026 in LaPorte County, Indiana. Timothy Lewis did unlawfully, knowingly, or intentionally communicate a threat with intent that another person be placed in fear of retaliation for a prior lawful act, and said threat was to commit a forcible felony. That count is a level 6 felony. It's punishable by a sentence of between 6 months and 2.5 years, with 1 year being the advisory sentence, as well as a fine of up to $10,000. Count 2 alleges battery on a person under 14 years. He was over the age of 18. The charge is a level 6 felony. It's punishable by a sentence of between 6 months and 2.5 years, with 1 year being the advisory sentence, as well as a fine of up to $10,000. Count 3 alleges resisting law enforcement, a Class A misdemeanor. That count reads on or about the 30th of March 2026 in LaPorte County, Indiana. Timothy Lewis did unlawfully, knowingly, or intentionally forcibly resist, obstruct, or interfere with a law enforcement officer or a person assisting the officer while the officer
I cut some of his charges out because you don't need to hear that crap.
was lawfully engaged in the execution of official duty. That is a Class A misdemeanor. It's punishable by up to 1 year in jail and a fine of up to $5,000. Count 4 alleges public intoxication, a Class B misdemeanor. That count reads on or about the 30th of March 2026 in LaPorte County, Indiana. Timothy Lewis did unlawfully, knowingly, or intentionally appear in a public place or place of public resort in a state of intoxication caused by the use of alcohol or a controlled substance, and breached the peace or was in imminent danger of breaching the peace or harassed, annoyed, or alarmed another person. That is a Class B misdemeanor. It's punishable by up to 180 days in jail and a fine of up to $1,000.
Excuse me, Your Honor, can I just say one thing? First of all,
Hold on, Mr. Lewis.
Yes, sir, but...
Yeah, listen to me. You have the right against self-incrimination and the right to remain silent. Anything you say in this hearing can be used against you. You don't have an attorney representing you today. So making any statement about what happened or didn't happen or the facts of this case is not going to help you, and the court's not going to get into that with you.
Yes, sir, but I was just saying I never even seen no one last night. I was in the back of a car. The cops pulled me out of a car. There was no female. There was no one around.
You need to talk to the attorney about that, Mr. Lewis.
Yeah, so I don't even see what am I being charged with because I was in the car. They pulled me out of a car.
Well, Mr. Frodoso read the charges to you. It's not whether you agree with them, it's just that you understand what you're charged with. You may be correct and you may have defenses, or these charges may be incorrect, but we're not going to get into that today.
Yes, sir. I do want to let you know I do have a job. I miss work. I am working. I do get disability, and I was going to ask you because I got my kids. I'm the only father that's taking care of my kids right now. My kids are at home. They don't even know that I'm in jail. I was asking if I could have an OR to go back to work, and that way I can pay these charges. I mean, pay for everything.
If I may, Your Honor.
Yes, sir.
Mr. Lewis has a pending level 2 felony dealing case in DO1, and this is now his third pending case in this court. So the state would be asking for no less than a standard bond for a level 6 felony in this cause.
All right, thank you. On the Superior 1 case, did he bond out or is he on pretrial? I guess not on pretrial.
I can see what the docket says.
All right, it doesn't matter. Mr. Lewis, the best I'm going to do for you is set your bond at $750 cash. I am not going to lower that. I'm not going to give you an OR bond. So you got to post $755.
Yeah, but
I bond out. You have Mr. Paycheck hired in your other 2 cases. You can use $750 of your cash bond if you do bond out to hire your attorney in this case. All of your cases are going to be set for May 11th, 2026 at 12:45 p.m.
Your Honor, but I get disability. I have no way to get a hold to my bank account to get the money to bond out. I do get it.
I have to work through that with your family or friends. I can't.
I have my mom is dead. Me and my wife are.
Rusty and Luna
all
are your
3 cases are
doggies?
set to May 12th,
I can't see your icon well enough.
2026
My eyesight sucks. So are Rusty and Luna your doggies?
at 12:45 p.m. I am issuing a no contact order in favor of the minor.
Yeah, but I don't even know who this is. That's what I'm saying.
Well, then it shouldn't be a problem.
Yeah, I don't. That's why I don't even know how I even got that charge because I wasn't even around no one. This
Initials JL. You already have no contact with that person whatsoever. That person by telephone, texting, through the use of any.
Anybody want to take a guess of what the judge's initials are? JL.
App, through any computer, through any social media, through any third party, none at all. That is a.
Yes, sir, but I don't even know who. I don't even know.
Then it shouldn't be an issue. Then it shouldn't be an issue.
It shouldn't, but I don't even know who that is.
All right,
you gotta give me no contact order on people. I don't even know who it is. Huh?
He said you're excused.
So I gotta pay $755 to get out.
Yes, sir.
CJ,
oh my
he did
God.
not say you
Man,
were
this is crazy.
CJ.
I got charges that I don't even know what's going on. You know what I'm saying? I don't even know who that person is, bro. Hey. They fucking came in and arrested me out of the back of a fucking car.
All right, Mr. Webb, you're up.
State of Indiana versus Antoine Dupree, 406004, 1707 F6697, 1909 F6 1210. Mr. Dupree appears by video and by counsel attorney Ryan Beal. Looks like we're here on a 4.
When this judge gets good, he is really, really, really good. He doesn't take it to that level, this docket. The inmates take it to that level themselves, but he doesn't. But this judge is so good when he gets mad or when someone disobeys a direct order from him. That's usually when he gets mad. It's when he tells someone to do something and they don't do it. He loses it. And I think you can only see this judge here. I don't know any other channel that's playing this judge.
Petition for revocation suspended sentence in F6697. Mr. Dupree, were you advised of your rights before court today?
Yes, sir.
You understand what your rights are in each of these cases?
Thank you, Zach. Thank you very much. I appreciate it. And just so you know, I made fun of Papa John's pizza tonight. Oh my gosh. Not Metro. I would never make fun of Metro Pizza. You got Bobby. Bobby's a member. You're awesome. Thank you so much, Zach.
Yes, sir.
You have any questions about your rights today?
No, sir.
All right, I'm going to have Mr. Fredoso advise you of the fourth petition for revocation of suspended sentence.
Thank you, Your Honor. The fourth petition alleges that Mr. Dupree, who's on probation out of this court, has violated the terms of his probation, specifically condition number 4, which is to report for probation appointments as directed by the probation department. Excuse me. He has allegedly failed to report for appointments on January 7th and February 3rd of 2026.
Mr. Dupree, do you understand the fourth revocation petition?
Yes, sir.
I'm entering a denial on your behalf to the petition. Mr. Beal, where are we?
Judge, I'm sorry, I think he just got picked up yesterday, maybe today. I didn't know he was going to be on the court call. Every time he's released, I have trouble. He never shows up for the next court date, so I'm sure I've had a plea in this case for quite some time. Looks like he was picked up at the Lake County Jail.
All right, court sets cash bond aggregate of $750 cash for both cases.
But what is both? I mean, only have one offense, and it's been like 9 years now. I'm just ready to go to like DOC or wherever. It's just because it's back and forth. I done missed out some job opportunities and things like that. And I'm currently now I'm homeless now, but I had a job opportunity back and forth. The last time you all released me, it took me a day and a half to get back to Gary. So it's quite hard for me to travel from Lake County to here. And because I thought it the last time, because you had released the bond, I had bonded out, you had released the bond, and Mr. Bill had let me know that it was the case was going to be resolved. And you had released the bond. So usually when a judge releases a bond, the case has been came to a close or a resolution came to, and seemed like me.
Mr. Dupree, these cases are not resolved, so we got to get that done.
Judge,
how much jail time do I have?
can we reset this 1 week? We've had a time served plea. It's just that every time the court releases him, I think he was in front of regular court last time. He just doesn't show back up. But we have a time served plea. I will get up there before next Tuesday.
I did a part 2 in that subset, and it didn't go great because he wasn't that crazy. He was crazy because he's a subset, but he wasn't that crazy.
Get it signed. We'll get this in.
All right, all matters reset to April 7th, 2026 at 12:45 p.m. on defendant's motion, time charged to defendant. Court does set a $750 cash bond aggregate for both cases.
Mr. Dupree, I'll come up there either like Friday or next Monday, okay? We'll get this done next Tuesday.
All right, I appreciate it. All right.
All right, you're excused, sir. Thank you. Pratt, 46D04, 10503 F6357. Pratt, are you there?
That's right.
Yes, I am.
All right, show the defendant appears by video and by counsel, Mr. Beal in person.
I had to continue last bench trial day because Mr. Pratt and I had lost contact. We've since in the last 2 or 3 weeks have talked quite a bit. He understands what the plea offer is, but is not willing to accept it. So requesting that we put this back on the bench trial calendar and get it resolved that way.
All right, Mr. Pratt, I think we've been through this before, but I have to advise you again. You have the right to a jury trial in this case. Your attorney's asking for a bench trial, which means the judge only would be hearing this case and deciding this case, if you agree to a bench trial, you'd be waiving your right to a jury trial. Do you understand all of that?
Yep.
Do you agree with your attorney and you want a bench trial and you're waiving your right to a jury trial? Is that correct?
Yes, sir.
All right. July 29th at 9 a.m., 2026. All right, Mr. Pratt, this case is now set for a bench trial on July 29th, 2026 at 9 a.m. You are ordered to appear in court in person on that date. If you fail to appear, the trial can take place in your absence. The court can issue a warrant for your arrest, or the court can do both. Do you understand that?
Yes, sir.
Do you have any questions?
Yes, I do. I want to know if you can drop the order on my address so I can go to my house, man. She hasn't lived there in months now, and I want to go back home. I've been living out in the woods in a tent and all winter long. I've been staying in a storage unit, man. This is crazy. I can't go home. I can't get in my vehicle. I can't do shit. Pardon my language. I can't do nothing.
Watch your language, Mr. Pratt, please.
No, I apologize, Your Honor.
Thank you. What's the address you're talking about?
My house is there in Michigan City.
You said 475 West?
It's
875 West. Do you own that or rent that?
I'm buying a land contract.
Your name's on the land contract?
The whole thing's just in my name.
Well, I think Mr. Beal can advise you further. I mean, if the complaining witness is not living there, I'm sure he can go back, but I don't know what it says.
I was told by the cops that I'm not out on the property until I have an order from the judge stating that I can go back to my house.
Well, I can't give you an order for that if she's still living there. If she's vacated the premises,
I'm asking our advocate to reach out and confirm that the address we have for her is correct. So the current address is different than what he just said. So the address that we have, but I need to confirm that that is correct and that she's not at this address that he just said before the state can agree to anything.
He hasn't been there in 4 months.
So how soon are you gonna receive something?
We've been in.
Yep, we're gonna go to freezing tonight too. So I don't know what that means for gardeners in Pennsylvania, but it's gonna drop to freezing tonight.
Contact with her previously when this was set for bench trial, and she did come in and meet with me about the case. So I'm assuming that we should be able to get in touch with her within days.
Days, man. I've been out here like this for months. Out here in the cold, bro.
Josh.
All right.
I lost over 135 pounds.
Mr. Fredoso advised Mr. Beal of what the status is. And Mr. Beal, if you want to file an order with the court, if she's vacated, just
I will, Judge.
file an order and I'll sign it that he can return to his home.
We'll get that done, Josh.
All right, Bill. I appreciate it. I'm just irritated.
I know.
All right. All right. You are excused, sir. Thank you.
All right.
You are all excused, sirs. Thank you. Thanks for coming out tonight, guys. I really appreciate it. So tomorrow morning, or should I say in about 6 hours, I'm going to do a trial, but it's just going to be one stream long. It's not going to be like a week long. It's a brother and a sister. They're both lawyers, and they're suing each other. The audio is not the greatest. It's not, you could hear. I mean, it's loud. It's just a little garbled. The microphones aren't great, but I have captions. But if you really hate listening to garbled audio, then tomorrow is a good day to skip. Sleep in. You know, go drink yourself silly tonight, and then sleep in. If not, I'll see you all in about 6 hours. Thanks for coming, guys. I really appreciate it. I hope that you guys have a great day. Bye, guys.
thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.